next speaker is going to be Pielpa Ollikainen from the Erik Castrén Institute of the University of Helsinki. And yeah, she's a doctoral researcher there, and her research interests mainly focus on environmental law of the EU, access to information rules, and environmental democracy in the EU. Yeah, we're looking forward for your presentation.
All right, thank you very much for the kind introduction as well as the possibility to be here today on this panel to talk to you. I'm very excited and also a little bit nervous. Now, my intervention today is going to be based on a draft article I'm working on titled EU Policy Between Economic Coercion and Persuasion, Threading the Needle. In this intervention today, as well as in the article, I want to focus on the legal definition of economic coercion in the anti-coercion instrument, to which I will be referring to as the acquis from here on out. And I want to contrast this with EU environmental policy that extends EU regulatory requirements beyond EU borders. And to this end, I'll use the Carbon Border Adjustment Mechanism, or the CBAM, as an example. The article, as well as my intervention today, also revolves around the broader rubric of the EU's understanding and legal position on trade-related leverage. Now, by trade-related leverage, I generally mean EU attempts to use trade-related measures in order to induce a change in either third country policy or in the manner in which third country actors conduct their business outside the EU. I think these two legal instruments, so the acquis and the CBAM, reveal two different views that the EU holds on trade-related leverage and more generally economic interdependence, which is what facilitates that leverage. The acquis portrays interdependence and leverage negatively with the EU as its target, whereas the CBAM and EU environmental law more generally portray or harness interdependence toward positive ends, at least from the EU's perspective. I should also note that my angle of entry here is an international or at least a transnational one, as I'm more interested in how these developments fit in the broader rubric of international law, rather than adopting a purely internal EU perspective. Now, I'll first lay out the acquis definition of economic coercion and how I see that the EU seems to understand it. Then, I'll juxtapose that stance to the EU's attempts to influence third country actors through the CBAM. Rather than approaching this as a question of compliance with international law, although that is an interesting and important question, as you all know, the Treaty on European Union commits the EU to strict observance as well as development of international law, I instead want to do something a little bit different. I want to look at how congruent the EU position is between these two instruments. My contention is that once we subject the acquis and CBAM to thorough scrutiny and look at how they fit with one another under international law, we find incongruence. And actually, I'm going to propose that rather than seeking to then make them coherent, we should first embrace parochialism in examining the EU's legal position on economic coercion, because this results, if not in a better, then at least a different understanding of legal developments. Now, this in turn requires downplaying law as an emanation of justice and legitimacy, and instead emphasizing its strategic utility in distributing burdens and benefits between different actors. Ultimately, I think this helps in determining what stance we as lawyers, as the audience of these developments, want to adopt on how wanted those developments are and how we come to understand them. So first, what is economic coercion? The acquis defines this as a situation in which a third country applies or threatens to apply a third country measure affecting trade or investment in order to prevent or obtain the cessation, modification, or adoption of a particular act by the Union or its member states. For the sake of convenience, I'll simply refer to the Union from here on out. Coercion is channeled through EU private actors. It affects their profits and business and investment opportunities. Coercion imposes costs on legitimate use of policy space and hampers the exercise of governmental authority independently. The EU holds that economic coercion is contrary to international law, and more specifically, to the principle of non-intervention. Now, if we are to reconstrue the EU's legal argument here, as a matter of legal argument, this ostensibly means that the third state is attempting to influence the EU on choices that ought to remain free by virtue of the principle of state sovereignty, as put by the International Court of Justice in the Nicaragua versus US case. Now, this is generally taken to refer to the concept of the domaine réservé. In doctrine, this concept can be understood in two ways. Either as an area that is wholly untouched by international obligation and defined in a purely residual negative way, or in a sphere in which a state maintains discretion even though it has assumed certain international obligations on that subject matter on the whole. I note that the EU also states in the Acquis Impact Assessment that its World Trade Organization obligations do not touch upon the question of coercion, right? Coercion as a matter of customary international law. So in other words, the EU attempts to divorce the infringement of non-intervention from international trade law. This, in essence, to me means that for the EU, the understanding of the domaine réservé is that second option, right? Discretion. Now, I note with interest that in that very same impact assessment, the EU also makes a distinction between economic coercion and permitted forms of influence. This, to me, is the first clue that the EU is by no means willing to relinquish its own trade-related leverage. This kind of leverage, as I intimated earlier, is very common in EU environmental legislation. Many EU regulations in that field include what is known in scholarship as territorial extension, so the inclusion of an extraterritorial component which conditions the conduct of actors outside EU borders. For example, the CBAM puts in place market entry conditions that are determined by conduct outside the territory to which EU law applies. This is very deliberate. What the EU is trying to do is influence third state actors as well as third state governments to decarbonize, right? You find this intention on the face of the regulation itself. For the EU, this is legitimate. I take no stance on that right now, but for these states that are so targeted, that influence can easily be as unwanted and as economically harmful as economic coercion is now for the EU. It also perhaps does not come as a surprise that the EU also considers that the CBAM is fully in compliance with international law as it holds for the Acquis, as well as actions to be taken potentially under that instrument. So this to me means two things. The CBAM first is compatible with international trade law, even though it has been widely disputed on that front. And second, it is not an infringement of the principle of non-intervention. This kind of influencing is economic persuasion. It is not economic coercion. However, in order to distinguish between economic persuasion and coercion, the CBAM then logically, as a matter of argument, has to target something that is outside third states' sovereign discretion. And I think the EU is very conscious of both the need to make this demarcation as well as its difficulty. To this end, the Acquis definition also includes that when the EU assesses whether there is economic coercion that targets it or the member states, it has to pay attention to whether the third state tries to tackle a legitimate concern that is internationally recognized. Coincidentally, this is how the EU justifies the extraterritorial reach of its environmental policy. The CBAM, as well as other notable examples such as the Aviation Directive, which was very controversial, are presented as attempts to tackle common concerns, notably here, climate change. So to me, the inclusion of this aspect in the Acquis definition of coercion is also an attempt to shield EU environmental policy and make that delineation between persuasion and coercion stick. Now, as you may hear already from my demeanor, I do not find this particularly convincing as a matter of coherent legal argument. If the EU can reserve itself some sovereign discretion that's independent from its international trade obligations, so too would I think that third states can reserve similar discretion in responding to common concerns. Trying to make that persuasion coercion delineation coherent reaches the end of its limit here. As an explanation, However, this is not necessarily the end of the story, right? Strict observance of international law as well as its developments. And we've heard that now there are indeed developments that perhaps call for developing international law. Non-intervention is a notoriously indeterminate norm, and the acquis can also then be seen as an attempt to develop that norm. Here, the crucial question will be what the wider audience of states and lawyers makes of the EU's assertions on this front. And here, I think one absolutely has to view the EU as self-serving in order to be able to say whether its legal stance is a welcome development of non-intervention. And to this end, I note with interest that the EU's position on economic coercion is actually reminiscent of that of the Global South, originally articulated during the push for a new international economic order. That was a redistributive agenda pushed through the auspices of the General Assembly. Its purpose was to correct systemic injustice and thereby alleviate the position of the Global South. However, I am not convinced that this is the manner in which the EU is now approaching economic coercion. It instead seems to me that the acquis is not a departure from the kind of economic interdependence that has been beneficial for the EU. Rather, it is an attempt to actually shield the EU from the unwanted effects of that interdependence now that they have arrived at its door. To this end, I also note that the CBAM, as well as other examples of environmental legislation that have an extraterritorial component, are accused of being neocolonial or imperialistic. So, it appears to me that indeed the acquis is an attempt to retain as much of the gain, so that is status, resources, authority, that interdependence has brought the EU now that these are threatened by geopolitical strife. And in that task, legal argument is extremely prevalent and extremely useful because it allows actors to transform their parochial interests and pursuits into what is ostensibly a fact that we can all then presumingly agree on. This is a task in which I think law is as ubiquitous as it is in any discourse of justice. However, such gains must be defended, and it's in that continuous struggle that strategic openings present themselves. I think the EU, as I explained before in defining economic coercion, has been aware of this strategic opportunity for contestation. And it seems to me that for anyone trying to contest or even appraise legal developments, being able to spot those openings is crucial because they allow for opening another avenue to articulating how such developments are good and for whom. I'll leave it at that. Thank you.